All right, so let's get started. It looks like we have our first speaker with us, so that's good. And we have our representative for our second group and our third. So we are in good working order. Good morning, everyone. My name is Laura Reichart. I'm the director of the Hawaii State Center for Nursing and also the chair of this working group. This is a working group to study the feasibility and impact of the state adopting the nurse licensure compact pursuant to Senate Concurrent Resolution 112. I am going to take a roll call of the members of the working group. If I have not called you, then you are either a public member or you are invited as, or you are participating as a member of the public. So please note that we know that you're here, but just calling working group members out at this time. So myself, Laura Reichart, present, Director Ondo from DCCA, good morning. Then we have a representative of the Department of Commerce and Consumer Affairs Regulated Industries Complaints Office, and we have both Rena and Esther present. Good morning.
Good morning.
We have representatives from the Board of Nursing. We have Leanne Tashima and Chelsea Fukunaga present. Good morning.
Good morning.
We have a representative from Senator Keohokalola's office. Excused. We have both Senator San Buenaventura and Amelia Castro. Good morning.
Good morning.
We have from Representative Della Albaladi's office, we have Tom Heinrich and Hector Venegas.
Yep. Good morning, everyone. She should be joining shortly.
Okay, wonderful. Thank you. We have Rep Nakashima. Did he pop in yet? I don't see him. Okay. And then, or do we have Lori Hasegawa? Not yet. Okay. So excused from the Healthcare Association of Hawaii, do we have Paige Heckathorn Choi? Excused, we have from HGEA, Jesse Sleva. Good morning. From the representing the Hawaii Association of Health Plans, I see Jen Diesman. Good morning.
Good morning.
A representative from the American Nurses Association Hawaii chapter, I see both Linda Beechner and BJ Bartleson. Somehow I have a middle name instead of the top. And I see that Representative Bellotti has just joined us. All right, so that is us. And then again, as well as myself, we have Amy Ono from the Hawaii State Center for Nursing. And then I did see that we have our first two speakers, Robert and Nicole from NCSBN. So I just want to recognize that you're here and thank you. So with that, does anybody have any comments or corrections to the minutes? All right, we can post them for the record, and then we can move on to the content section of our agenda. So I just want to provide a little bit of framework. This is our last meeting that we are inviting people to comment and provide information for. We have invited NCSBN to come and speak with us. So they have 25 minutes. We asked them to comment on the continuing competency requirements between member states and also any other matters. So if you have questions for NCSBN, this is your time to ask them. Then we have had some ongoing discussions about how that disciplinary action process happens between states. And it was recommended to us that we invite Tennessee and Delaware because they've undergone this experience. And so they will be present with us to have that conversation. And then we're going to have some time with DCCA to talk about the fiscal obligations of the state. And then again, any other matters that is of interest to the working group. So that, again, this is your opportunity to discuss with them. And then we'll end the meeting with a 20-minute discussion. And that will be that's the agenda for today. So with that, I want to, one, recognize that Paige did join us. So we'll mark you as present. Thanks. Good morning, Paige. And then I also want to welcome Nicole and Robert back to the stage. I have multiple participants can share. So if you have anything to present, you are more than welcome. Otherwise, welcome and thank you for being with us today.
Thank you, Laura. We really appreciate being here again before this group. Just as a reminder, Nicole Ivanos, I'm the Director of State Affairs for the National Council of State Boards of Nursing, and joined with me, I have Robert Krebs, who's an associate within our State Affairs office. We are glad to be back. We were here, I think, for the second meeting of the work group, and so glad to be here for the very last meeting. I'm going to go ahead and share my screen. We just have a couple of slides. We're happy to address the two issues. Let me go full screen here. Can you all see the slides?
Looks great. We're seeing the presentation view.
Oh, you are? Okay, so am I, which is odd. Let me see real quick. Okay, can you now just see?
Nothing changed. It would be fine if you just show kind of the slide deck and click through it.
Yeah.
It would be a pretty big screen.
That's what I was hoping I was doing. Hold on a sec.
Okay, that looks fine right now. But now you're muted.
Okay, can you guys hear me?
I hear you and I see the slides.
All right, I am getting a message that Zoom quit unexpectedly. That just keeps popping up. So Robert, I may have you switch over to sharing the PowerPoint if that happens again. But thank you all. We will start on our first topic, which is continued competency. So here is the data, and we're sharing data today from what's called the NCSBN member board profiles. And all of this data is accessible to the public to look at. It is based on a survey that is sent annually to boards of nursing, asking them questions about a variety of topics, including licensure, board composition, nursing education, and other areas, just to get sort of a survey of the boards on issues to see if there's any changes, between licensure requirements, for example. What are the most common licensure requirements? We can see the data of, if there's any trends towards, eliminating certain requirements or adding certain requirements, whether it be for board composition, again, licensure, education, et cetera. And one of the questions that we ask around licensure is issues around renewal or reinstatement. So if you have left the profession and you are coming back to practice nursing for whatever reason, what are some continued competency requirements that could satisfy that requirement to reinstate your license, or continued competency requirements for renewal as well. So here we have broken up the jurisdictions by RN and LPN, and we ask who requires continued competency, who has some sort of a requirement for renewal. It's important to note here that the N is 54 nursing regulatory boards. So we do survey all of the jurisdictions, the territories, DC, as well as the US states. And so just so that you know, that is the N that we are working with here. So you'll see that 47 jurisdictions for RNs and 46 for LPNs have a continued competency requirement for licensure renewal. So what does that continued competency look like? So here are the methods to meet continued competency requirements that we survey for. This is for registered nurses. You'll see that it's color-coded and also alphabetical, so stick with me. And we'll see that the most common method for continued competency requirements is B, which is continuing education hours. 43 jurisdictions do that. And the asterisks here are methods that are allowed in Hawaii for registered nurses. So of course, continued education hours is one of those. The second most is I, which is maintenance of RN certification. Again, also allowed and authorized as a measure for continued competency for nurses in Hawaii for RNs. And then tied at 22 are C and F, which are periodic refresher course, and F, minimal practice hours. So again, those are elements that are being able, that our nurses are authorized to show to demonstrate maintained continued competency. For LPNs, we have a very similar setup here with 42% or 42 jurisdictions allowing continuing education hours. In second and third place tied are C, F, and G, which is a periodic refresher course, minimal practice hours, and that are paid, and minimal practice hours unpaid to demonstrate continued competency. So since the most common requirement are continuing education requirements, we wanted to break down the number of hours that states reported requiring of renewal applicants. So the largest chunk here is in green, and that represents 21 to 30 continuing education hours per renewal cycle. That being said, the renewal cycle does depend on the state and when that is, when they do their renewal, although it is often every other year, sometimes all at once, sometimes on the licensee's birth date, sometimes on the date of issuance of licensure. But generally it's on a 2-year cycle. So you'll see that the majority of jurisdictions, 24 jurisdictions, fall into the same category as Hawaii, in that they require 24 or 21 to 30 hours of continuing education for renewal. That same demographic has 22 jurisdictions shared in it for LPN continuing education hours. The second highest is 11 to 20 hours, and that would be 12 jurisdictions for RNs and 13 for LPNs. And then you see that the highest number of hours required by a jurisdiction, more than 30, are only 2 jurisdictions for both LPNs and RNs as well. So to talk about multi-state licensees and continuing education requirements specifically, it's important to remember that in order to get a multi-state license, you have to first meet the requirements of your home state. And then you go on to meet the 11 additional uniform licensure requirements. What's important about that is not only do you have to meet the requirements of your home state, you also need to maintain those requirements upon renewal in your home state. And so as we saw, very common for some continued competency requirements to be required of renewals upon renewal for licensees. So that is going to remain in place in those jurisdictions that are in the NLC. Those nurses will have to follow the renewal licensure requirements in their home state. And so for many of those jurisdictions, that means completing continuing education requirements. When we talk about a non-NLC environment, if a nurse is holding multiple licenses, they also have to renew multiple licenses and meet the continued competency requirements of each state. And so while a lot of states do allow for general continuing education hours, meaning they don't specify the topic in which you have to complete a CE in, they just have general 30 hours, 20 hours, et cetera. There are some states that do require specific state-specific courses on, for example, suicide prevention and other specific areas. And so you can imagine that if a nurse is holding multiple licenses and not only renewing those licenses at different times, but they're also completing CEs that may be in a variety of different areas required by that jurisdiction. One of the concerns that's been expressed in states about the NLC and specific to continuing education requirements is that the concern is that multi-state licensees from other jurisdictions participating or practicing in our state do not need to complete our CE requirements. So from the perspective of a non-NLC NLC state, they would say a multi-state licensee coming from a different jurisdiction will not need to complete our requirements. They may have to complete their requirements, which may or may not be very similar to ours, but nonetheless, they're not completing ours. So we wanted to provide, and I think we talked about this when Robert and I first presented, but that there are ways to add different policy to the Nurse Licensure Compact legislation in order to address some of these concerns. And Washington did just that. So in Washington's law, they put in language that requires that individuals that hold a multi-state nurse license issued by a state other than Washington, so not home state licensees, and are employed by a Washington regulated facility shall complete the suicide assessment, treatment, and management training required by law as a condition of employment. So what this is doing is saying that for those multi-state licensees that are employed by Washington employers, they must complete the CE that is specific on suicide assessment, treatment, and management training in the state of Washington in order for that entity to employ that nurse. So that is one solution that states have looked at and are exploring. I will say that states that are not in the NLC yet, this is something that they are looking at, especially if their jurisdiction has specific CEs for specific reasons that they want their licensees to complete. This is one way to create a solution in statute in the bill language for the NLC to address that concern. So as an example, for Hawaii, Hawaii could have language that says for multi-state licensees not domiciled or multi-state licensees where their license was not issued by the state of Hawaii, they must complete the Hawaii continuing education requirements as required for licensees in Hawaii as a condition of employment. So that would be some alternative language if the CE concern was there. There could also be, some language in there for jurisdictions that already require continuing education, that so long as they're maintaining that CE requirement in their jurisdiction, that they would not be subject to this as a condition of employment. So there's definitely a lot of ways to write this language that might help to address some concerns for continuing education under the NLC. So I will pause there and just ask for questions specifically on CEs before we move to COVID-19 emergency declarations.
Thank you, Nicole. I have a quick question. It looks like RCW 43.70.442.5A is, when I look it up, it looks like it's under the Department of Health, not under the Board of Nursing, although I don't know where their Board of Nursing is situated. Do you have information about that?
Yeah, so it's a CE that's required for a lot of different professions. And so it's mandated by the Board of Health. Is that what you said? Which the Board of Nursing, Department of Health.
43.7 is titled the Department of Health.
Yeah, so that was probably just general licensure requirements for healthcare occupations in the state.
Okay, thank you.
Can I just add to that really quick? And I think, Nicole, probably what you're looking at is there are some requirements sprinkled throughout DOH, sprinkled throughout their HAR and their HRS that hospitals and nursing homes and other folks are already expected to comply with. So I would guess that just the way that it was pulled together, Nicole, by the folks putting this together was they just said, this is what we already require of hospitals. So it's more of a reference rather than, some kind of new requirement. It's just referencing existing statute that's already being used. So it wouldn't change anything necessarily in what the state does. It just applies what the state already does to NLC requirements.
Yeah, absolutely. So Washington nurses already have to meet this requirement upon renewal and demonstrate that they've completed this training. And so this would be a way to ensure that multi-state licensees that are employed by Washington employers also have to meet the requirement. But yes, this is not a new requirement for multi-state licensees only.
Nicole, this is BJ from Hawaii Nurses Association. However, I would assume they would have had to add the language that individuals that hold a multi-state licensure are now required, correct? So that
Exactly.
language would have to be added. Yeah, okay.
Yep, thank you, BJ, for pointing that out. Yes,
Yeah.
this would be one of those examples of a way to put into the NLC legislation added elements that address common concern or address this concern. So this would be something that Hawaii would craft language under. Again, you would reference the appropriate Hawaii statute for CEs, whether that be located under the Board of Nursing Nurse Practice Act, and you would make that requirement and place that into the bill. So as a reminder, the NLC legislation, although you can't change the core elements and sections of the NLC bill, you can make changes to statute that could again address some of these common concerns within the same legislation as the NLC.
Great, that's helpful. Thank you.
Thank you.
All right. Yep, thank you, Laura. So I will now turn it over to Robert, and we will talk about COVID-19 emergency declarations.
Awesome, fantastic. Nicole, if you wouldn't mind going to the next slide. And just in the interest of time here and not being the guy to derail your whole meeting agenda, I'll keep it brief, and whatever we need to pad out with questions, we can certainly do that. So obviously this should come as no surprise, but in addition to the federal public health emergency and emergency declaration, every state, territory, and DC declared a state of emergency related to COVID-19. Most of these came sometime around mid-March 2020. And what I'd like to talk about here are two tools that can be used in response to public health emergencies and natural disasters. They're both compacts. One is the NLC and one is the Emergency Management Assistance Compact. So starting with the NLC, if you kind of think about the structure of it, it is in a way built for states of emergency. So the status quo under the NLC is, if you have a multi-state license, you have the ability to practice in your state as well as a privilege to practice in all other states. So that means that, if a emergency pops up, you can already deploy to another state and provide care if they're in the compact without needing to obtain an additional license. And also, you don't need to wait for a disaster declaration because that's a privilege you already have under the compact. So in essence, if a disaster occurs or if an emergency arises, that pathway for getting more nurses in already exists under the compact. Turning towards the Emergency Management Assistance Compact, this is a compact that every state, territory, and DC, except for American Samoa, participates in. And part of this compact, Article 5, addresses occupational licensure reciprocity. So under this, there can be reciprocity for occupational licenses, permits. The difference here is that under this compact, a disaster needs to be declared. So when a disaster is declared, you can stand up this reciprocity provision. And additionally, it can be subject to limitations or conditions as imposed by the governor. So they have a little bit of, latitude to tailor it as they see fit. The other important thing to note here is that it's not an either or situation. These do not legally conflict. So if you're part of the EMAC, that doesn't mean you can't be part of the NLC. They should both be viewed as different tools that can serve the same cause, which is obviously responses to emergencies and disasters. Next slide, please. And now this is a graph that shows the temporary license waivers that were stood up during COVID-19. Paige, I'll pause this so you've got your hand up.
I just want to comment on that, Robert. I want to give an example of the EMAC, if it's okay, and how it applied in Hawaii. So as some of you might remember, we didn't just bring in nurse travelers, right, for the surge staffing for the hospitals. The federal government actually did send in their own people at one point to set up the sub-Q monoclonal antibody sites, right? So we had some positioned at hospitals on Oahu, on Big Island, but we also had one out in Waianae, at the Waianae comp. And so part of, I think that what I really want to note here, Robert, is that EMAC, right, why you would want to have a potentially an emergency declaration is we got federal funding in order to set up those MOAB sites. But also what happens sometimes is these are federally designated or federal employees who will come in. So for those monoclonal antibody sites, it was folks who through the federal government were essentially employed by the federal government coming in. So it was a little bit different. And I think I just want to make sure that that's clear, is that when you have those EMACs, it can come with a lot of other federal resources. And I just wanted to provide that as a specific example of something that happened in Hawaii during the Delta phase, where we were able to get just purely federally funded staff, supplies, treatments, and all kinds of other stuff through the EMAC, and because we had that state of emergency in play. So I just wanted to add that. Sorry, Robert.
Thank
No,
you.
no worries. I'm sure that's very helpful for everyone on the call and certainly helps fill in and contextualize it for me. All right. So kind of turning back to the temporary license waivers that were stood up during the pandemic. And you can see here I've pulled a graph that uses NCSBN data that was compiled by Brookings. And what is really important here to highlight is just the significant variation between states in terms of what licensing flexibilities were offered to whom and for how long. So for instance, some states allowed out-of-state providers who were licensed in good standing to practice in their state without needing to obtain a license. Others expedited pathways for licensing out-of-state providers, and some did both. It was really kind of difficult to say that there's an apples to apples comparison here, because states, while kind of falling in some broad thematic categories, had differences in language, differences in duration that were really important. So what really came to be was this kind of patchwork of different state level waivers that, while similar in many respects, had many important differences as well. And as you can see here, there's this quasi-national compact that stood up during COVID with all of these licensure waivers, but these ended at very different points in time. So this graph here is showing when a state's final licensure waiver expired. Some of these were as early as the back half of 2020, and some were even in effect until this summer. So that's trying to give you guys a just general picture of what happened during COVID in terms of these waivers, the variability within them, and then some of those broad buckets, whether it's you can practice in our state, if you're in good standing in another state, you have an expedited licensure pathway, both, some combination. There really were a lot of different flavors to it. And then final slide, please. And the last thing that I just kind of want to walk you guys through here, and this is something that Nicole and I touched upon in our first presentation when we talked about the NLC and discipline, is just this case study in terms of what happened in Missouri and New York and what they had to contend with during the pandemic. So on the left, you'll see kind of the facts of the case, and this is something that Missouri and New York actually had to contend with. So in March 2020, New York issued an executive order that allowed nurses licensed in good standing in another state to practice in New York without needing a New York license. What happened was a nurse who was licensed in Missouri as an RN, we're calling her Nurse A, diverted drugs while practicing in New York under this order. And they wrote a statement admitting to this conduct in April. Their employer filed a complaint with the board, who, after looking into the case, basically said, they're practicing under this order and we don't have jurisdiction to investigate. So they declined to pursue the case, citing that lack of jurisdiction. And it made its way back to Missouri only because the employer decided that they were going to notify the Missouri Board of Nursing. So the Missouri Board of Nursing was notified. And then it took all the way until November of 2020 for them to hold an administrative hearing just to determine even if they could pursue discipline in this case. Ultimately, it was determined that they were able to, and following an investigative hearing by the board, the nurse's license was revoked in July of 2020. So I think what's important here is to just kind of tease out what happened as New York was a non-compact state, and then I'll walk you through kind of hypothetically how this might have been different had New York been in the NLC at the time. So specifically, New York's order allowed these qualified nurses to practice without civil or criminal penalty related to lack of licensure, but it failed to really clarify the board's jurisdiction over these nurses. So as a result, the board couldn't take action against the nurse. And, obviously, if we're looking at drug diversion here, there's a possibility of patient harm and harm to the public. The other part here is that New York had no mandated reporting requirement. It was only because of that employer, as I said, that Missouri found out about the misconduct. So had New York been aware of this at the time, the case could have been much different. Let's say New York is part of the NLC. In that case, they would have had clear authority to investigate and discipline the nurse. They would have given the case the same priority and effect as if it were a New York licensee. Essentially, we're treating it just like anything else, and they could have had their own authority to discipline the privilege to practice. They also would have been required to report this conduct to Missouri for them to take any action against the nurse's actual license. So if they report it from New York to Missouri, Missouri can then take action against the entire license, in this case, say the multi-state license. What would have happened here is we would have avoided some of those jurisdictional questions and empowered both boards to take the action necessary to protect the public from conduct happening in their state. And I just hope that this example has been just an informative way of teasing out some of those differences, some of the problems that can arise when you're trying to stand up these emergency procedures, and then how those would be already kind of accounted for under the compact. And with that, I believe that's all of the slides that we have. And depending on timing, we're obviously happy to take questions.
Yeah, we have, we're ahead of time based off of the initial schedule. So our next panel or our next group of presenters starts at 40 past the hour. So we have about 9 minutes for lots of questions.
So Robert, this is BJ from Hawaii ANA, and just in case, thanks for presenting that. So let me back up. So in the New York, Missouri case, because I guess what I'm trying to say is if you're a multi-state license holder and you go to another state, the state that you're not multi-state licensed in still has the opportunity to investigate, right? They just can't revoke a license.
Yes. So what they can do is they can suspend, turn off, do whatever they want with your privilege to practice. And that functionally, so let's say you're in New York on a privilege to practice, you're a multi-state licensee whose home state
Right.
is Missouri. You do something that New York says we want to take action against that. They absolutely have the power and the authority to discipline that privilege to practice. So they could say, we're turning off that privilege to practice. You have no authorization to work in New York. They would then refer that to Missouri, the home state, and Missouri is the one that holds the license. So what Missouri could do is say, we're going to place an encumbrance on this license. We're going to suspend you. We're going to revoke it. And in that case, the license would be revoked and all other privileges to practice in every other state would automatically be turned off. So if they place any encumbrance on the multi-state license, all privileges to practice go away. So that's not just New York and Missouri, that would be any other participating state.
Got it. Thank you.
Mm-hmm.
So Robert, can I just clarify there? So would that mean then that, for example, New York might say, we're going to notify Missouri, but New York wouldn't have notified anyone else, right? Essentially. So it would just be 2 states that would know compared to all the other states in the NLC being aware of the encumbrance.
So they would be required to report it from New York to Missouri. Nicole, do you kind of want to talk a bit more about the nuts and bolts about how that would work? It's a bit out of my depth sometimes.
Yeah, absolutely. So the way that it would work, and so again, we're picturing that both Missouri and New York are in the compact for purposes of this example. And so if a nurse, again, diverted drugs in New York and they held a multi-state license issued in Missouri, New York could take any action against their privilege to practice. Any action that they have available to take against licensees, they can take against the privilege to practice. So the whole range of disciplinary options are available to them, just as it would be for a licensee from New York. So once they take that action, that's considered an encumbrance, an adverse action on their license, that is available for all compact states to see. Similar to if there is public discipline inputted into nurses on a licensee, all boards of nursing have access. The compact mandates the sharing of that information. So they would find out potentially at two instances about that licensee's conduct. One, when New York took action against the privilege to practice, and two, if Missouri also took action against the license of that nurse. So that information is mandated to be shared by the compact states. That is different from a non-NLC situation where you can upload that final discipline into nurses and other states can see final discipline, but it's not mandated like it is under the compact.
I just want to know a question that I have in my mind that is not 100% pertinent to the nurse license compact, but it does seem like the emergency proclamations, which continue to be used even when states have nurse license compacts adopted, has that loophole where if there is a disciplinary issue that needs to be investigated, there isn't necessarily a standardized process. So it seems like, and I'll just maybe parking lot that, but note that because we currently use emergency proclamations, and it looks like whether or not the license compact would be adopted in our state, we would still continue to use emergency proclamations. That may be something that we want to investigate for the future. So I just want to note that and say that may be a gap that needs to be addressed in the future. I do have.
I think Laura. Oh, sorry. I was just going to comment. That might be just something to bring to the AG, because I think the AG would do the emergency proclamation.
Yeah, and right, and I don't
they
want
could just
to
not have that.
I'm just recognizing that that's outside of the scope of this working group, but certainly something that we've discovered in this process is. Leanne had her hand up.
Yeah, I couldn't find a raise hand button.
Oh, it's okay.
Anyways,
your hand worked. Your physical hand worked.
For Nicole and Robert. Hi, Nicole. I just saw you on another meeting earlier.
Yes.
So, in that example that you guys just had, is there a case that you know of where another compact state, a non-compact state, did investigate the nurse, even though they're not part of the compact? That's my first question. My second question would be, are you aware of any case where there was the compact state where the nurse's home state, I should say, did not take action when the nurse diverted drugs in a non-compact state?
Okay, thank you, Leanne, for those questions. I might need help on the first one. I'll go with the second one first. So what happens under the compact scenario, and I can't speak to any specific examples of diverting drugs, for example, that was one case study used to sort of exemplify the issue with having temporary patchwork solutions, especially in emergency settings where we know that, there's an emergency. And so there is a lot of potential for, for falling through the system. But I wanted to talk about the second one first. So is there a situation, what I'm hearing you say, when a nurse is disciplined in a compact state, so they're working on a privilege to practice, let's just say, let's use Missouri and Kansas as an example. They're a Kansas licensee, they're practicing in Missouri, and they, commit an action that results in an enforcement action by the state of Missouri on their privilege to practice. You're asking, is there a situation where Kansas does not take reciprocal action on that nurse's license?
Yeah, that would be another question, but yeah, I'm talking about compact versus non-compact. So in your
your first scenario.
Yeah.
Yeah.
Well, yeah, and then yeah, I can go in that order.
So your first.
Sorry.
Yeah, so under your first example, you were talking about the situation of Missouri and New York, because New York is not an NLC state. And so there wasn't action being able to be taken by New York under that, under their waiver issued by their governor. However, like Robert said, one size doesn't fit all for these emergency, emergency orders and emergency legislation during COVID. So some states did have a process by which they said, by practicing in our jurisdiction, even under your license issued in another state, you are subject to the enforcement regulation of the Board of Nursing, for example.
Oh.
And so there are under those emergency proclamations situations, of course, where there were better systems set in place whereby the Board of Nursing did have jurisdiction over that individual, even if they were practicing without an issued license or temporary registration or anything in that state.
Okay.
So definitely there are examples. I think this one was highlighting something that could have fallen through the cracks had Missouri not been able to establish jurisdiction over that practice happening in New York.
I see. Sorry, I didn't hear that part. Okay. So if a home state takes action against a multi-state license by revoking that multi-state license, does it automatically, so that individual no longer can practice in any compact state? Is that correct?
Correct.
Okay.
If the
And
home state takes action against the license, it's an encumbered license that turns off the privilege to practice in all NLC jurisdictions until the encumbrance is lifted.
Okay, so if someone holds a multi-state license in one state or in a home state and then practices in a multi-state or a licensure compact state and diverts drugs or whatever they do, and then that state, that NLC state, takes action against their multi-state privilege, do you know of any mechanism that triggers and requires the other states or the home state to take action?
So thank you for that question. So let's talk about a scenario just because I think it helps to talk about state names. So in Kansas, I'm licensed in Kansas as a multi-state licensee, and I'm practicing across the border in Missouri. I divert drugs in Missouri. The Missouri Board of Nursing is able to take action against my privilege to practice. They decide that they're going to revoke my privilege to practice. Is there a requirement that Nebraska takes action against that license based on, against the privilege based on Missouri's action? No, there is not a requirement that they do that. However, they are able to access that information. They are shared that action has been taken, and the state is able to take action against the privilege to practice should they wish.
So if
So
Hawaii,
that would be Nebraska's decision over whether or not they believe the conduct that occurred in Missouri. Now, again, if it's diverting drugs, I'm going to think that Nebraska is going to think that that's a threat to to public safety and take that action. But if we're talking about something different that Nebraska may decide is not would not be a violation under their laws, they still have authority under their jurisdiction to allow that nurse to practice there.
okay, so if Hawaii were to join the compact, could we amend the compact law to require, or how can I say this? So if someone's multi-state license privilege, I'm trying to think how we can put something in our nurse licensure compact that would automatically allow us, without actually conducting an investigation, based on another state's disciplinary
You don't
action.
need, so here's a question for you, Leanne. Today, if you have a licensee that is licensed in Hawaii and they're also licensed in California, and they have an action taken against them in California, what can the Board of Nursing in Hawaii do?
Well, we can take action against them.
They can take reciprocal license discipline. That is exactly the same under the NLC. There's no added provision that is needed there. You will be able to access the information of any PTP action, privilege to practice action, taken on any NLC multi-state licensee in any jurisdiction to the NLC, and make the appropriate decision for Hawaii based on that action.
Okay. All right. Thank you.
Yeah.
Thank you, Laura.
Thank you. And then we do have 15 minutes after our next speakers to have more questions. So I'm going to ask BJ, do you want to ask your question now and we can just kind of move everything down, or do you want to wait until?
No, it's a real quick question. It's a
Okay.
yes or no question on this tongue twisting topic. Nicole and Robert, is there any agency or does NCSBN keep track of disciplinary action on NLC licensures? Is there some type of data?
Yeah, so every
Saved.
nurse or every state participates in nurses, including the state of Hawaii. And within nurses, you can look up a nurse and any public discipline on their record is listed within nurses. So there is that database. On the private side within boards of nursing. They have access to even more information to be able to communicate and protect the public. And within the compact, certainly there is you can have a data breakdown over what actions were taken against an individual holding a multi-state license, specifically even further, which ones were taken against their privilege to practice in a jurisdiction, or what actions are taken against single state licenses. And I think in week 2 also, Laura, one of the documents that you shared within the agenda was the disciplinary study done by our research team here at NCSBN that looked at disciplinary rates among multi-state licensees and single state licensees and found virtually no difference. If anything, multi-state licensees had less disciplinary action than single state licensees, but by a very minimal margin. We know overall nurses are safe. They're safe practitioners. They have very, very low disciplinary rates. But when we did do the breakdown among the compact jurisdictions and multi-state versus single state licensees, we found, again, virtually no difference between their disciplinary rates.
Thank you so much, Nicole. And then thank you. I want to thank our next speakers, Sherry Richardson, the Executive Director of the Tennessee Board of Nursing, and Pamela Zicafus, the Executive Director of the Delaware Board of Nursing. You two were recommended to us by NCSBN, by Nicole and Robert, to describe how you have handled a disciplinary issue in the past. I just want to say we are a little bit over time, but we do have that Q&A period as a buffer. So please do take your 10 minutes. And thank you so much for joining us and being patient with us as we move through those questions.
Thank you for involving us. We're so excited to be a part of this. This conversation has been wonderful so far, and I'm happy to share our experiences in Tennessee. So would you like me to just answer the questions that were sent to me?
Yeah, you can answer the questions, or if there's kind of like a however best you feel like sharing that process. I think we've had a lot of questions, as you can see, how that would how that engagement works between two states once something awry does happen.
Absolutely. And please bear with me. I've been on the road. We're doing school survey visits, but I wanted to be part of this conversation. So I apologize for any background noise. Okay. So the first question was describing an issue where a multi-state license holder required investigation and how, as the primary state of residence state, that issue was received and processed. So each compact state has the authority to investigate a nurse with a multi-state license. So any state, if their home state is Tennessee and it's our licensee, and that nurse is practicing in Kentucky or Missouri or any other compact state, and there is a reason for an investigation, that state has the authority to investigate that and to discipline that compact, that multi-state privilege to practice in that state. So once that happens, if the state chooses to, if that board of nursing in the remote state chooses to discipline that privilege to practice, and as Nicole said earlier, in any way, any kind of discipline from a probation to all the way up to revoking that privilege to practice in that state. Once Tennessee gets the message that this has happened, Tennessee will automatically convert that nurse to a single state license, because that nurse now has discipline in another state. And so they are no longer eligible for multi-state licensure. So that does protect all the other compact states, because we would switch that nurse to a single state licensure while we conduct our investigation. Now, the compact states work very well together. The compact law gives us the authority to work together and share this information so that we can be unified in what we do with these folks who have issues. And so I can tell you that Tennessee frequently, if not always, disciplines those nurses who have a privilege to practice discipline in another state. So does that help a little? I hope.
I think, and maybe I'll ask, I think the people who probably have most interest in this, I think everybody has interest, but Rena and Esther and Leanne and Chelsea, if you have any practical questions, I think it'd be nice to hear from you. And Pamela, I don't know if you had anything else to
I
add.
just like to, can you hear me, Neil?
Yeah, you sound great.
Okay. All right. I'd like to apologize. I didn't realize the meeting started at 4 o'clock my time instead of 4:30. So I apologize for coming in late and not hearing the whole conversation with Nicole and Robert. But as far as a discipline, I think, and I'm not sure how much everyone, from the question about nurses, I'm not sure how much everyone understands about nurses, the National Nursing Database. I think Nicole did a great job explaining it. All disciplinary actions are entered in there. An example I can give for other states taking action against our state, for instance, we had a nurse in Delaware who failed a CE audit. And every time a nurse has any discipline whatsoever, once that is entered into nurses, and they are our agent for the National Practitioner Data Bank, they submit our disciplines up to the NPDB. But as soon as it goes into nurses, a speed memo goes out to all the states where that nurse is licensed. So those other states can then take action or not take action. So I had a nurse in Delaware, failed her CE audit, and she happened to be a traveling nurse. So she had to get licenses in every state, or I'm sorry, telehealth nurse. So she had to get licenses in every state. I think just made her do additional CE and maybe a minor fine. Well, 17 other states took action against our discipline for failing a CE audit. She was so mad at me and Delaware for that, but that is the other states' rights. As Leanne also asked, your law hasn't changed. Your state laws still prevail. And when these remote state nurses work in Hawaii, they're going to have to follow the Hawaii scope of practice, rules and regulations, and all of that. So that's one example. Second example I have this morning, I got a call from one of our facilities people, inspectors, and they found a nurse who was working in Delaware who lives in Maryland and is practicing here on the Maryland privilege to practice. And she basically instilled the medication and whatever into the balloon of a G tube and popped the balloon, and patient had to go back to the hospital. And so basically they have to file a complaint. She will get the process, because that's the first question I see is what's the process? So this investigator from our state will now go on our website, file the complaint through the Delaware Board of Nursing against this Maryland nurse. And then our investigators take that information, they investigate, and then they take their findings and submit it up to our prosecuting district or deputy attorney generals. They will then take action against the privilege to practice. We enter that. And if it's something really egregious, as Nicole mentioned, like a drug diversion, anything like that, I most often will just pick up the phone and call the executive director in that state and say, we have an issue. This nurse that's licensed in your state is remotely working here, and we're going to take action. And my understanding is that any actions we can take against any license from NPDB, from, as Sherry said, letter of reprimand all the way up to permanent revocation, including those emergency temporary suspensions, can also be taken against your privilege to practice. So once this girl's investigation concludes, we will then take action. It'll go into nurses. Maryland will be notified, and we go from there. So that kind of is in a nutshell how we do the disciplinary process regarding remote states. And we really don't have that many. We really don't. It's not a major issue. I was talking to our investigative supervisor this morning. I said, how many do you think we have? And we can probably count them on one hand within a year, how many actual privilege to practice disciplines we would have. So there, that's my 2 cents. Thank you. What questions do you have, Neil? Leanne, yes. Hi, Leanne. You're muted.
Oh, sorry. Hi, Pam.
There you are.
I have a question. So does your laws and rules require that the hospital's director of nursing or the employer of the nurse, whether they're practicing on a multi-state license or not, or a single state license, report any quote termination or resignation of a nurse while they're investigated or after an investigation has occurred?
Do you mean, if you mean the hospital's investigation or
yes.
ours?
There's
We have duty to report laws in Delaware that do require anyone to report unprofessional, illegal, or incompetent practice to the Board of Nursing. We also have a duty to report law for incompetent other medical practitioners. We have the duty to report for child abuse. So yes, they do report to us when
Okay.
someone has had something. And again, being a small state, they pick up the phone and call me in most cases. I'm serious, they do. It's like, Pam, what do we got? We got this nurse and she did this. And just like the lady from the state that called me this morning, and I will show them into the complaint process so that we have a paper trail and we have it documented, and then we go forward with the investigation from there. But yes, the hospitals do let us know.
Okay. Thank you. Thanks, Pam.
Sure. And again, you have to have a good relationship with your hospitals too. We work very closely with our hospital association, who, I know a couple of people have mentioned about the fraudulent Florida schools and all that, but anytime I get information, most recently, Leanne, we just got I think everybody got the email that we have 2 more schools that have been added, new affidavits. So what I do is I send out an email to my hospital association, healthcare facilities association to cover all the long-term care, the home health association, and they share that information with their HR department so that they can then, watch out for people who are coming to work for them from those schools. And nurses is such a wealth of information too. Sending speed memos through nurses is just, it's such important information that we have in there. Okay, I see lots of hands.
Wow, really?
Who you want? Who would like to go next?
I'll
Thank you,
jump
Pam.
in. Hi, Pam, this is BJ. Thank you for your
Hi.
example of the CE business.
Yes.
So that it sparked a question in me about the time frame between, you get a complaint and
Mhm.
then what's the time frame, or what are the triggers till it goes to nurses?
It really depends on the complaint itself. If it's an egregious complaint, for instance, we had a nurse that had a heroin needle in his leg at work. That immediately goes in. We have the ability to put in significant investigative data ahead of time before we even finish an investigation. And at that point, those boards that have questions, they can contact us and we can provide them with the information, what we're investigating and what's going on. And especially if we're the remote state and they're the home state, I am most certainly going to call that EO and tell them that this is going on in our state and go from there. So that's, that's how
So
it
basically
happens
you
normally.
can report even just a complaint, a disciplinary complaint on nurses.
Right.
Okay.
Yes,
Thank
we can
you.
through nurses. Mhm.
Okay.
Paige?
Oh, I'll
See
have
hands.
Chelsea go before me. I think it's more
Chelsea,
appropriate if
okay.
Chelsea goes ahead of me. Yeah.
I just had a quick question. Did Delaware have like an emergency I guess something to waive licensure during the COVID pandemic? And if you did, what were like the terms? I mean, just like briefly, and how long it lasted?
We had the COVID waivers. Anyone coming from out of state had to submit a paper form to us so that we had record of who and all was here working in our state. We kept track of that. They had to abide by the laws of Delaware when they practiced here in Delaware in any of our facilities. And our state of emergency was lifted in May when the federal state of emergency lifted. Now the COVID waivers, I want to say they ended a while ago. Maybe January of what, 22 maybe? I'm not 100% sure. They didn't last as long as the full state of emergency did. Since then, you know, we've done telehealth registrations now where they have to actually apply for a registration and provide information. So we've tightened up the process significantly compared to just having a paper submitted for the COVID pandemic.
Okay, thank
That
you.
answer your question?
It does. Thank you.
Okay.
And I'll go and you know, I'm thinking that part of the reason, Pam, and Sherry, I know your connection is unstable, that not every state's part of the compact, right? So you would still need a waiver potentially if you did want to bring in folks from other states. And that might be part of the reason why you guys would want to maintain the waiver, is what I would think. Right. It's just if the AG was looking at it. So I did want to ask a couple questions actually, and I really appreciate Sherry and Pam, you guys talking about the investigations. I think one of the questions that we've had on this call before is, you know, we have RICO, right? And RICO has this very special place that's a little bit more separated, which I think is a really good way to set up a lot of these investigations. And so I don't know if you can talk about, do you guys have sort of like a RICO equivalent where it's not the Board of Nursing doing the investigations, but it's a separate entity doing the investigations? And then sort of as a subset question, whether or not your investigation process changed at all when you guys joined the compact, or if it's gotten easier, if it's gotten more difficult in some ways, or, you know, if there's somewhere in between. And then the second question after the investigations would just be, if you guys are willing to talk about the potential fiscal impact of joining the compact. That's a discussion piece that we've had a lot. It would be really helpful to hear your folks' experience with going to the compact and how that might fiscally impact the Board of Nursing. So sorry to put in two questions, but if you could help me with those two, those are kind of the big questions I had outstanding.
All right, I'll start and then I'll let Sherry chime in. I feel like I'm taking the whole conversation here. Delaware is an umbrella board. So that means that we are not a standalone nursing board. Our investigators are not under the Board of Nursing, nor have they ever been. We have our own investigative section of our division of professional regulation. So they're not nurses, they're not nurse investigators. So and nothing has changed before or after the compact. So, you know, I would say that, you know, does that answer the first question more or less? Okay. So the second question, what was it now? I'm forgetting.
I'm so sorry. I'm notorious for doing this. I want to ask them all at one time. One of the questions that we had was the fiscal impact, and I think there's a concern. Yeah. Okay. Right, about what happens, right, if you can't charge. Yeah. And so how has that affected Delaware and Tennessee? Okay.
Delaware has been a member of the compact since the original one back in 2000. So we've been in it for over 23 years now. And when we did implement it back then, we saw no difference. We saw no change in the fiscal impact. And what's interesting now, you know, most recently, New Jersey went with just joined the compact, which is a contiguous state to Delaware. Ohio joined the compact, and we have a lot of licensees from Ohio because of all of the insurance companies and everybody that gets, you know, licensed for telehealth and all of that. So I was really, really worried. We just had our renewal of RN licenses and APRN licenses finished the end of September. And I was really, really concerned about how many people we were going to lose because of that. There's no difference in the number of licensees that did not renew from this year as opposed to 2 years ago, 4 years ago. You know, we normally lose about 3,000 or so, and it's about the same this year. So even though other states have implemented, we've not lost that much revenue. And what I see coming in every month from the new graduates, from people endorsing into Delaware, it evens out. So we haven't experienced any major impact to date. Now I'm still weary and concerned when Pennsylvania gets their license implemented, but you know, we'll measure it when that happens again. So Sherry, do
Thank
you
you.
want to
Thank
add
you so
something
much.
here, please?
I've been adding into the text as you've been talking, Pam.
Yeah.
You know, Tennessee's been in the compact for over 20 years, which was before my time with the board. But I do recall my predecessor, Libby Lund, mentioning that there was no real significant change that we saw. And as nurses move around, which they do, then once they decide that if they're from another compact state and come to Tennessee and decide that they love Tennessee and want to stay here, at that point, they seek licensure here, and we do get that revenue, and they become Tennessee's licensee. So, I mean, it's been kind of a wash for us, is my understanding.
Thank you. Thank you both.
Thank you. And then
Esther
we'll
has
take-
a hand up.
Yeah, we'll take Esther's question and then we'll move on to the next presentation. Thanks, Esther.
Okay. Esther? You're
My
muted,
friend, you're
Esther.
muted.
Okay. Hi, Pam.
Hi.
Thank you for that good information. I was really curious about what you said, which is that, that Delaware is a standalone board.
No, we are not.
Oh,
We're
okay.
not. We're
So,
an umbrella. We are an umbrella board, not a standalone.
okay, when you say you're an umbrella board, does that mean all the professional and vocational licensee categories fall under you as far
Our
as enforcement
division,
goes?
yes.
Okay.
Every category is under our division of professional regulation. We have 54 boards and commissions under the umbrella of the division of professional regulation.
And how do you interact with the specific boards that issue the licenses?
Well, I'm the executive director for nursing. We have our division is divided into 3 teams. I have 12 other boards besides nursing under me. I have the dentists and hygienists and podiatrists and geologists and nursing home administrators, funeral service practitioners, et cetera, et cetera. So I have a staff of 5 people, and I have 2 board liaisons who divide up all the other boards. I have an admin 3 who is my board liaison for nursing. She and I do all the work for nursing. I have 2 other staff. One is a licensing person and one is a credentialing person. And between us, we do all the applications, we issue the licenses, we do the renewals, we release the holds. And I'm in there with getting my hands dirty every day, basically doing the same things that my staff are doing, in addition to my administrative duties, such as basically running reports through nurses and all of that. So I don't know what just happened. Can you still see me? My I got kicked out.
We can see you.
You look and sound the same.
Oh, okay. Well, my thing says that I'm not in the meeting anymore, so I'm joining now. I don't know what happened there.
You're here, Pamela. We can see you and
just
hear
went
you.
dark. So
Oops.
sorry about that.
Okay, so my question is, who handles enforcement?
Here.
There was a lot of questions about reciprocal discipline and so forth earlier during the call. How exactly is enforcement handled by your agency?
It's me. Again, we're a very small board. We only have about 28,000 active licenses. So when a nurse is disciplined, we have an online computer system that has disciplinary actions in it, and I monitor the nurses themselves. Whenever today I just sent out emails that people's CE was due back on the 12th. I mark it off, I put it in our system, which then goes out to the public side that people can see, oh, the CE was done on this date, the fine was paid on that date. And then I also go into nurses and file a report. Today I just did a 1280, which means that the license was restored, full and complete. So it's me. Unfortunately, it's a small board. And again, Sherry may have other staff that do it. So Sherry, how about you?
Yes, well, I'm an umbrella board as well, and so there are, I think, 42 other boards. I only, thank goodness, I'm responsible only for nursing. Our investigation side is separate from us, although it's under the Department of Health, and our investigators are nurses. But I have 20 staff members that includes myself, and that handle the different licensure applications and the application process, as well as CE and everything else. The investigators work with our attorneys. Once the investigations are complete, of course, the attorneys then work for to get the orders together and to bring the cases before our board. We have a disciplinary coordinator who handles taking all of that information and putting that into nurses so that it can be reported to nurses as well as to NPDB. So, does
And
that
that
help?
reminds me, we do have a hearing officer unit with a paralegal. So for all of the board ordered disciplinary actions, initially, our paralegal is the person who's entering the information into nurses that goes up to NPDB. But once the disciplines have been decided, basically, and the board has accepted either consent agreement or hearing officer recommendation or issued a board order, then I'm the one who actually monitors them here in my, in my office to make sure that they are in compliance.
Thank you. That was very informative. It seems like the state of Hawaii is a little bit different from your organizations in that there is a separate agency, not a part of the professional vocational licensing division, that handles all of the enforcement responsibilities for all of the industries, and that would be us. That would be RICO. So I just wanted to make that clear that we're a little bit different from Tennessee and Delaware.
And that's the beauty of it. Really, all states are different.
Yes.
And, in the compact, you still retain all that state sovereignty. You get to do everything that you normally would do. Nothing changes with the compact. It's just that the license that issues is multi-state. They're allowed to work in the other compact states, but when they are working in those other states, they have to follow those states' rules and regulations.
Thank you,
Yeah.
Pam.
Thank you, Pam.
Thank you, Sherry. Paige, you have one more question, but we are
Quick question.
over time.
Yeah. So, okay.
Is it a real
I
quick
think so,
question or is
Pam
it a
and-
Paige question, Paige?
It's a quick question. Thanks, Laura. So Pam and Sherry, I just want to confirm. So you guys do all of the investigations and then the discipline, and that is, I just want to confirm that. So there isn't any separate entity that does the investigations within your guys's orbit of licensing. It's all done
That's correct.
internally. Okay.
Yes, for Tennessee, yes, ma'am.
Delaware, we have our investigators under our division. They're not affiliated with the board, but they are under our division.
Okay, so you would then refer then any cases to this kind of separate entity under the division, but not, so it's like
Right,
a division of licensing. So they
All
are a little bit separate. But
all
Tennessee,
complaints.
it's all, got it.
All
Okay, so all
would go
complaints for
to the
any
investigators.
licensing.
Yeah, all complaints go to the investigators. From the investigators, it would go up to the prosecuting DAGs, which is totally separate from us whatsoever. They are the ones who make the consent agreements or schedule a hearing or whatever. And then once that happens, then those consent agreements, the board recommendations would come to the Board of Nursing for a decision. And the board, it depends upon what kind of an agreement it is, but the board does not get involved or have any knowledge of complaints or anything until we actually get an order before the board to decide.
Got it. Okay. I don't know, Esther, how that, sorry, right, Sherry.
That's okay. That's how it works with us as well. I work on the licensure side, and so I will see the board orders at the board meeting with the board members when they make the decisions.
Me too.
Got it. Okay.
Me too. I
Thank
don't see
you.
the
Thank you for
complaints.
clarifying.
Yep, I don't see any complaints or anything unless, like today, the lady called me personally, and I just referred her to the investigations people to put in the complaint. So
Thank you so much, Pamela and Sherry. And Sherry, please safe travels. We appreciate you being on the road and taking this this meeting. And if there are any other questions, we can, if you're able to stay on the line, we'd be happy to engage you in dialogue later. If you need to go, if you're available, we'll email any questions that we may have to you. Thank you so much.
Thank you.
And
thank you. I think because of the time difference, I'm going to go ahead and go. Please feel free to email me any questions you may have.
Thank you. We will do that.
And, you know, I'm sure Nicole and Robert can get up with me as well. So thank you very much and good luck. Take care.
You.
Thanks,
All right.
Brenda.
And
I'll do the same. Thank you.
Thank
Bye,
you,
everybody.
Sherry.
Good seeing you. See you, Sherry.
And then at this point in time, we are going to have Chelsea Fukunaga present our next section, which is related to the fiscal obligations of the state, including any fees and other costs. And there is a number of questions that we had posed to DCCA to answer. And so she'll be presenting on behalf of Director Ondo. And then I'm just going to move on. We do have then the next section is 20 minutes to ask any other questions or any other matters of the working group that deem applicable. So if there's any questions that DCCA wants to pose to the working group or the working group wants to pose to DCCA, that's the time. So thank you very much, Chelsea.
Okay, can everybody see the screen?
Yes, looks good and you sound good.
Okay. Okay, so this is our presentation. Okay, so we just did a snapshot of fiscal year 2023 and 2024, noting that we're still in fiscal year 2024 and it does not end till next year, June 30th. Some of the variances that you're going to see in the figures are due to, we just came out of a renewal period. So that will explain why some years may be have more revenue than others. So this is between just last fiscal year and the current one. Sorry, did I? Okay, yeah. And then I'm sorry, the previous one was on the numbers of licenses. I'm sorry, I'm looking at the wrong side. And then this is the figures for the fiscal 2023 and fiscal 2024. This is from what we could gather from fiscal year 19, 20, 21, 22, 23. And you're going to see in the renewal years, except for 2021, and that was because we transitioned to a new system. So there was a bit of a hiccup in the renewal process, but you see we recouped that in the following year with restoration fees and so forth. This is the current staffing that we have budgeted specifically for the Board of Nursing. We have 5 application clerks who handle both exam and endorsement applications. We have 2 clerks that handle our records. So they are, once the applicant is licensed, they handle the renewals, restorations. We have 1 secretary that's dedicated to this, or he's not dedicated. We are an umbrella agency. So with the exception of 1 clerk, everybody is, well, sorry, let me restart that, I'm sorry. For our office assistants, out of the 7, there's only 1 clerk that has other assignments. The rest are dedicated to the Board of Nursing. For the secretary and the 2 EOs, we all have other assignments in addition to the Board of Nursing. And so this is just the base salary plus fringe. Of the percentage of staff, this is coming just from the PVL office assistants in our licensing branch. So out of the 7, it's 33% of the current staffing in licensing branch. Out of the secretaries for PVL, we have 1 secretary to 11%, and we have 2 executive officers that are assigned to the Board of Nursing, and that's about 14%. And this is, I was requested to put this on. So these are the top states that they had listed their addresses as out of state. So they reside out of state, but they are licensed in Hawaii. So this is the states that tend to apply to Hawaii. You'll notice that California is the only non-NLC state. And the reason why I put this on here was just to show that this snapshot was taken October 11th of this year. And then the number of nurses that held NLC license and resided in NLC state and also held a Hawaii license was, when you're looking at the figures, it's not everybody is able to qualify for a multi-state license. So despite having high numbers from NLC states, it doesn't mean that everybody has a multi-state license. So it's just something for the working group to keep in mind. And this is figures from non-NLC states, and I want to caveat this slide. I went off of the NLC website as to who is not currently part of the NLC. So if this information is a little off, I do apologize. It was just going off of what I could find. So if this has been updated, I will make the adjustments at a later time. But this is our figures of the current licenses who have noted licensees who have noted their addresses in these states. And to kind of give you an idea of like our current licensees who have listed their addresses in Hawaii. These are the numbers. I hope that if we should join the NLC, they will continue to reside in Hawaii and work here. But it also just, if it's a 10%, you know, it's giving you real figures as to what we could lose. So just a snapshot of that. So part of the cost benefits for joining. So some of the pros is we potentially could have less applications to review. So it would basically replace the endorsement process for nurses coming in. This is potentially, this isn't guaranteed. That would then require less staff to review. And I want to caveat that with, it means that the staff may be reallocated to other assignments, other boards, and not necessarily just be assigned to nursing. Workload may lessen because we have less applications, and we could become more efficient due to the lessening of the applications coming in. Some of the cons is that we may generate less revenue for the board and overall PVL. It may lessen the overall staffing for PVL, so it hampers the ability for us to hire new staff or sustain our staffing, depending on whether or not we're in the red. The lessening of the workload isn't guaranteed. Even though we may lose endorsement applications, there may be an increase in multi-state applications. This is something I guess we'll figure out as we go along. If we do join the NLC, there is a lessening in our income, and we do reallocate staff to other areas. We may not be easily able to reassign them to nursing should there be a surge in new applications. And then it could also lead to greater staff turnover, our ability to hire people. I mean, we already are affected by this as it is, but in the long term, if our staff is overworked because there's more applications than we have staff to process it, this could affect our workers. And that could in turn make longer processing times for everybody, not just nursing. So some of the challenges, if we should join the NLC that we have highlighted, would be we would need additional staffing to handle both our current workload and then handling training for trying to implement the NLC. There's going to be a lot of training for all of our staff, EOs, the secretary, the applications clerk included. We will need funding to upgrade our system so that we'll be able to transfer that information. And then the projected 2-year implementation, this is just projected as we don't know exactly what is going to be needed until we join. And we're going to need time to train and to make sure that we work out all the kinks in the system. So some of the previous meetings, we had been asked about our temporary staffing. So we were able to hire up to 10 relief workers, and this is through the Corona State and Local Recovery Fund. This is in addition to the 7 application staff and our secretary. We were able to help us. So Leanne previously presented on our processing times, which did improve when we added the additional staff. It cut our processing time in half. So this is from the previous presentation. So as you see, after March, we started to see a decrease in our processing times. And this is because we had hired additional staff on top of the current staffing that we had. For the fiscal year 2023, this was the number of applications we received every month. And for fiscal year 2024, this is what we have received up until now. And so this is just giving a an idea of what the current workload is for our application clerks and what they're processing. I do want to note that this doesn't mean that this is licenses issued. This is just what we've received. So they are in certain states of there's deficiencies or they may require further review. These are the licenses that were issued by month. This can also be tracked through our RAT list at every meeting, through our minutes and our agendas. And this is showing that we are pumping out quite a bit of licenses every month. And it does increase, as you can see, with the additional staffing. Also, this is more of a, I'm so sorry. My screen just went black. Let me just pull it up. So to kind of give you an idea of the number of applications that we received and the number of licenses issued, this is the apps received, and then this is what they're processing throughout the month. So of all the areas, our application clerks are, they most likely have the most applications to process. And this is just giving you an idea. And this is for fiscal year 2024, this comparison, the amount of applications we receive and licenses issued, which is quite a bit, actually. I was really surprised when I saw the numbers. In conclusion, it's unclear whether or not we will benefit from a workload issue in terms of lessening the amount of applicants coming in. And this might be affected if we do join. It could be that we may get a lessening in applications, but then I don't know how that's going to be with multi-state licensing, if that's going to increase and then that's going to equal out. Our staffing levels may be affected. We may not be able to keep up with the demand. I think that it's unclear whether or not we'll benefit in the long term. License portability doesn't necessarily equal license or an increased level of nurses in the state. I think emergency proclamations were demonstrative of that. We had a lot of nurses coming in, but choosing not to stay. We didn't really see an increase in the level of nurses staying here. But yeah, that's the presentation.
Thank you so much, Chelsea. So at this time, we are at 11:27 and we have really the rest of this conversation, or the rest of our time in this conversation, is to have open discussion. So we can have focused discussion specifically with DCCA, and then we can also open it up in general. I see BJ Bartleson's hand up, but Senator San Buenaventura, I'm going to pull rank and let you ask your question first.
Thank you very much. So I want to talk to the last speaker, Chelsea. Now, we passed the physician licensing compact, and I know that we gave like what 1 or 2 year period for implementation. Based upon, and so it may probably be too early to determine whether or not any of your concerns that you voiced is being borne out by that by the physician licensing compact. But do you have any kind of indications based upon so far? I mean, it's just been a few months since we passed the physician licensing compact, whether or not there's going to be more inflow rather than outflow, whether or not we're going to have the staffing shortages that you are concerned with, anything like that, Chelsea?
Well, I want to preface, I don't know, I'm not intimately involved at the medical board. I do know that they haven't implemented it yet, so it's hard to say at this point. Nobody's used that privilege yet because we don't have it quite up and running yet. So I think you're correct. It is a little too early to tell.
Okay, but do you know whether or not the indications of the medical board regarding the whole staffing concerns you had, whether or not they're struggling with it so far? Do you know?
I don't know currently, but I can find out for you if you'd like.
Okay, thank you.
Okay, and BJ, you are next.
So Chelsea, BJ, quick question about those monthly numbers of new applications. Are those totally new applications, or are renewals mixed in that?
No, that is the number of applications we received, and we did it by date. So
Okay.
it's not representative of the amount of licenses issued. I just want to clarify that for everybody. That was just new applications that are coming in
Okay.
every
But
month.
then you also had a slide with licenses issued.
Yeah, so I did have that, but I also, it was to give you an idea of what the current workload is for our application staff. So on top of the applications that we're receiving, that's also compounded by the licenses that they're issued. There might be a little bit of a mix between the two, but I just kind of giving you an idea of what the current workload is for the board.
Got it. Thank you.
I have a question for our employer folks who are generally, who are public members as well as HAH. So the premise is that with license portability, we should be able to respond to our recruitment needs of nurses in our state. But if we, and I don't know, Chelsea, if you can go back to that slide where you have the number of licenses issued. To me, I find that this data and I go to the Board of Nursing meetings, so I kind of track this over time. I find that this data is incongruent with what people in the working environment are saying, which is that it is very hard to recruit nurses. And so looking at between July 2022, and thank you for pulling this back up, and June 2023, so this calendar or this fiscal year or timeline for fiscal year 2023, we had 6,366 additional nurses licensed in our state. But that doesn't seem like to me, I'm like, that's a lot of.
Where are they? I'm
Where
with you. That's why I asked if those
Um,
were license renewals and new licensees, because I'm like, well, where are those 6,000 nurses?
And Chelsea remarked kind of at the end of her presentation, then it doesn't look like a lot of these are transitioned to renewals. They're kind of first and only time licenses. So my question to the employers is, how do you feel about this data? Does this also seem like you don't have as many nurses available to you, even though there's a large number of nurses licensed? And I don't want that question to seem biased, but that's kind of how I look at this data. Can anybody reflect on that for me? Darren, Darren, actually, it'd be great to reflect on that.
Yeah.
Hi, everybody. Darren Dunbar from Queens. A couple things came to my mind when as we look at that data. When the emergency proclamations went away, everybody had to apply for licenses. So one of the first questions when I saw that is, what's the discrepancy between we have this many applications and this many licenses? There was a second round of sort of an emergency process, and at Queens anyway, we would not take a traveler on until we had evidence that they completed their full application to the state. We didn't have because they were covered under that secondary proclamation, we didn't have a mechanism to understand if they fully got that license or not. I think our situation is less about nurses. I think we're struggling with what the rest of the country is. There's a nursing shortage. There are people retiring. There are people whose resilience have worn out and they're leaving nursing. So we struggle with the rest of the country, but then we add in cost of living, our geography, and some of these other things. I don't know that licensure, the biggest barrier around licensure currently for us is delaying people getting out here. We're still getting people out here. One other point I'd like to make based on the information that was presented, if I heard her right, she said very few of these nurses have stayed. That's not been Queen's experience, and I'm not sure what the end would be to make a critical mass. But in 2022 and calendar year 23 to date, Queens has hired over 50 of our nurse travelers. And we already have people hired in for January and February that are not counted in those numbers. So in less than 2 years, we've converted 60 nurses who were residents and licensed in other states to our state. That doesn't count new graduates that are coming out of school, which we've also hired more of in the last 2 years than Queens has in a long time also. So I don't know if that's useful information, but those are my initial responses.
Yeah, and if I can, Darren, thank you so much. I just really want to echo what Darren's saying. I do think that probably part of why you're seeing such a large number of licenses issued, but you're not necessarily seeing the growth that I think is being intimated by that would be attendant is because the waivers have gone away and then they came back and there were sort of emergency rules. I will say that our employers like Queens are really pushing everyone that they might bring in to actually be licensed in Hawaii because temporary licenses are not available. And we're very appreciative of the work that I think a lot of these, especially the CARES Act funded or ARPA funded, I can't remember which one it was, these folks who were able to come in, help get through the backlog, and be able to get these licenses processed much more quickly, and we're very appreciative of that. But there is a lot of stress, a lot of nervousness from our employers where they are asking everyone to get their Hawaii license. I can tell you that yesterday, between me, between our post-acute care director, between our CEO, we're getting a lot of emails and calls with concerns about the fact that the current emergency proclamation is set to expire on November 6th. And I know of a few organizations that are already trying to put in these applications for folks that they have who are actually actively handling cases on Maui, right? And there's a real concern about the continuum of care. So I really just want to echo what Darren is saying, is that I think because the process still takes time, right? It's not immediate, and it's not immediate in the way that the temporary licenses used to be, and there are no temporary licenses available. Our employers are just applying everyone for the licenses. So that's consistent among not just Queens, not just the hospitals, but our home health, our hospice, our nursing homes, all of those folks. It's to make sure.
You're saying, if I can summarize what you're saying, and I think Darren, you also alluded to this as well. Despite having an emergency proclamation, the employers in our state have worked in a situation that has still utilized the licensing process. So they haven't relied solely on the emergency proclamations. They are still having nurses licensed. So this data is probably pretty true to the total nursing workforce environment, because everyone who's coming into the state is really being asked to go through licensing instead of relying on the emergency proclamation. Is that a fair statement?
It is.
Okay, thank you. Jen, you had your hand up?
Yeah, thanks, Laura. I guess just one question maybe to Darren, because that was helpful, is your first comment was that the biggest problem Queens has is getting nurses out here, I imagine it's getting them out here quickly. So is that something that this kind of a compact would help with in terms of getting them here more quickly, so that then Queens could do the work of trying to retain them? And obviously you're doing a really good job of that, so congratulations. So I guess that's my quick question.
I do think it would help in the speed in our ability to get folks out here, because let's say you're licensed in the state of Maryland, it's compact state of Hawaii, we're a compact state. Getting a Hawaii license would not be a barrier to getting here. So, different people have different life circumstances and situations. The other piece, Hawaii is a transient state given some of our military population and again, our geography. So we see a lot of that, and we have a lot of people inquire about employment with us because they know their significant other is going to be PCS'd out here, that kind of thing. We were one of those, one of the agencies we work very closely with, like they have 900 employees who got full Hawaii licenses in the time they were here for the COVID surge and so forth. So if we continue to need travelers, we reach out to them and ask them if they have people that would like to return. That's helped a bit. Getting nurses out here is multifactorial. It's, the timeline to get a license is one piece of it, but again, our location, our cost of living, a number of other things. So there's not just one piece, but I do believe categorically that if Hawaii were part of the Nurse Licensure Compact, that would remove some barriers in terms of the expeditiousness in which we could get nurses here. Does that answer your question?
It does. Thank you.
And can I just add, I'm sorry, and this is sort of Darren sort of jogged my memory. I mean, I think that that's part of it is employers. Again, I just want to reiterate that employers are pushing to have folks licensed. And part of it was because when the waivers went away, right, we as employers, when we met with DCCA, when we met with PDL and Board of Nursing, what we were told was make sure you're applying your folks for licensure in order to have continuity of care, right? So I think that that's also where the employers are coming from. That's what our folks are saying is, especially on the home health and hospice and nursing home side, very concerned about the continuity of care. And that's also part of the push. So sorry, I just wanted to add that, Darren, because you kind of jogged my memory, where I think that we were in this culture of trying to apply folks because that's what we were asked to do on behalf of, you know, the state to help make sure there's continuity. So thanks, Darren.
BJ, you had your hand up.
Yeah, I have sort of the pros and cons of temporary licensure and the NLC. It's probably a question for Leanne and Chelsea. So if we had temporary licensure opportunity at the Board of Nursing, does that help with recruitment process? So we don't have that right now. Is that correct? Leanne, I think you were talking about this at the last meeting relative to trying to get temporary licensure up and running again. Would that assist some of the time issues relative to the licensees?
I'm assuming it would. That'd be up to the healthcare entities. So our vision of this happening is to issue the temporary licenses. So currently the process was to issue it pre-COVID within a few working days, but then it is attached to a permanent license application. So this person would have to submit 2 applications, one for the temp, have the healthcare entity or the hospital sign off, also submit a permanent license application by endorsement. They would have to get fingerprinted. They would have to get their National Practitioners Data Bank, and they would have to order a nurse's verification just for the temp. Okay, because it was tied to a permanent license application. So it was kind of useless for them to hurry up and get that because we couldn't process this permanent license application fast enough with the volume of applications coming in. So this past legislative session, we went in with an admin bill, and that got whatever
Right.
pass out, and they created a new bill, Senate Bill 63. So that got chopped away, the requirements. So it's not tied to a permanent license
to the permanent license.
Right.
Okay.
And the only thing we would require would be the nurse's verification. And that would to ensure that the person has a current license in another state that is not encumbered. We were going to leave it up to the healthcare entities, the employer, to do the criminal background check as required by, I think, some federal regulation. So we waived that part, right? And I know there was some issue with the funding, but that got taken out at the end, a position. So basically, you know, it was a clean bill as far as we could tell. There were no issues, but at the last minute, it didn't. There were probably other issues that the legislators had to contend with. So what we're trying to do is push that same bill now in our rules through our rules process.
Okay. Yeah, I remember you
that
talking
happen.
about that. Like, it almost seems like we could do some type of stair step, right? I mean, if it seems to me that would work faster. I'm not sure, but you know, what could happen in the short term? Could it be the temporary license without the commitment to the permanent license?
Yep.
And then can we weed out all of these other problems with the NLC relative to what we need to put into statute other than the model laws? So could we stair step that licensing process over time?
Yep.
Because even if we endorse the NLC, it's going to take time, right?
Yep.
That's going to take years.
So I think what the senator brought up, you know, comparing it to the recent passage of the medical compact, although very different from the nurse licensure compact,
way different.
Once that gets up and running, we could have data on how that's how that is working or how that worked. In the meantime, hopefully our temporary permit rules go through and our digitalized online process within the next week or two goes live, and then we can see what those numbers are like. But yeah, I think that would be our recommendation, just to because this is a really, I gotta tell you, I am very amazed with all the information, whether it's for the compact or against the compact, how Laura put all these different perspectives and have these different presenters. You did an excellent job, Laura. So,
Well,
you could
yeah,
see.
it really help. I think it really
Yeah.
helps. It helps us all broaden our,
Yes.
knowledge of it. But I
Yes.
still think, and there's probably a way to do both, right?
Mhm.
There's probably a way to, get rid of our concerns, and maybe we do it through statute, like one of the other state examples was, and maybe we stair step somehow so
Mhm.
that we can, make this more rapid and transition,
Mhm.
and then help us with safety of the NLC. But that's going to take a while, and I think there's a lot of good concerns on your part about the cost and the FTEs and those kind of things that we got to kind of put in perspective.
Yep, I
Yeah.
agree, BJ.
Jen, you have your hand up.
Yeah, sorry, just I guess, oh, did I just lose you? Okay, sorry. I guess, and I haven't been at every meeting. I apologize for that. I was traveling a couple of times, but I guess, BJ, I'm trying to understand based off of hearing from all of the other states and from hearing from the NLC directly, like I'm trying to understand what are the actual concerns? Like when you say safety, like I hear Leanne and I hear sort of the board saying, okay, there's a staffing issue, there's potentially a financial consideration that we need to think about. So I totally get all that and would certainly want to try to address those issues if we were to move forward. But I guess I'm really unclear, and or perhaps I don't agree that there's any safety issues that I've heard through all of these conversations. Like in some ways, I feel like it's even more empowering in a way. So I guess I'm just trying to understand.
No, I
what you
agree.
say
No,
there.
listening today, especially to Delaware, listening to their examples and the NCSBN's example of, I think one of my concerns had the time, so you have somebody under disciplinary review or look, so what's the time till that gets reported into NERCs so that another state would know that? So if that time element isn't long, broad, and they don't seem to think it's a huge, big issue, then it certainly, I think helps those of us that were concerned with that. There are a lot of stories about, nurses out there doing things for a long time in multiple states. Remember the Cullen gentleman, the nurse, working in several different states, and how many people were, killed, and nobody picked it up. And I think that was before the nursing licensure compact really hit the ground. But those kind of things, you have to wonder, are things getting reported? Are they put on the nurses in time? How long can somebody practice before somebody makes a complaint? So those questions come to my mind, but certainly thank you, Laura, for, bringing some of the examples today. Helps us go, okay, well, it could be a positive influence then.
Thank you.
Mm-hmm.
I was wondering, Laura, if it's okay, would it be possible, because I think Jen and BJ, you're bringing up the fact that, right, there's some questions about implementation, right? How does it all work? What are the mechanics? Would it be okay just to maybe ask Nicole, because I know we don't have Pam and Sherry, but maybe Nicole, since you have a kind of broader view of the implementation of this, are you able to just provide some general thoughts on the implementation and what kind of help could be provided? Because I know for the IMLC, I think the executive director came out and spoke to a lot of folks and tried to provide some help. And so I don't know if maybe from that macro point of view, Nicole, could you provide some insight?
Yeah, please, Nicole. Thank you.
Sure. Hi, all, and hopefully you can hear me. I'm now in transport, so I'm taking the Sherry route, but happy to provide some information on implementation. First of all, I think there's really two levels here. There's one of, the mechanics of the NLC and getting your processes in place from a technological standpoint, if there's any upgrades needed to the application system, because again, you'll be screening for 11 uniform licensure requirements. Many of them are going to be requirements already required by Hawaii's Board of Nursing for RN and LPN applicants. But if there are any additional, that would be, adding those questions to the application. So there are, some of those IT changes. However, Hawaii already participates in NERSIS. So what would be different there is that Hawaii would have different capabilities within NERSIS to take action against the privilege to practice, for example, or to flag between compact boards significant investigatory information. So those would just be added elements available for the Board of Nursing to use as part of being in the compact. I think the second piece of the implementation, and Paige, I think what you might be speaking to with the IMLC is then going out there and educating nurses and making them aware of the multi-state license, that this is an option, how it works, where they're eligible to apply. We know that there's a lot of advocacy from NSNA, the Student Nurses Association, who's very supportive, and they do regular education of nursing students on the NLC. I think similar to that, there would be that advocacy component as well that could hopefully be done by a lot of the group on the ground who want to, encourage the compact, the multi-state license, and for nurses to know that they have the option for it. So those would be sort of the two stages. Now, that being said, should there be concerns that Hawaii wishes to address through added language into the NLC legislation, those bits may have different implementation timelines, right? That's going to be unique depending on the state. I can tell you that Washington most recently adopted the NLC, and they had multiple different employer reporting requirements, CE requirements that we went through earlier, and also demographic data that needed to be provided by multi-state licensees to the Board of Nursing. That implementation is underway. So they passed it, I believe, in April, and so they're still going through that implementation process. But they, so it really depends on, what systems need to be stood up. But I would say that, the Hawaii Board of Nursing is already issuing licenses. They are screening for likely the majority of the 11 uniform licensure requirements. So the application process and getting that stood up would be, at the timeline of which the board feels they can complete those actions by. But on average, I'd say between 6 and 12 months. Probably closer to 6 is the average timeline for most of the states, but I can certainly find out the implementation timelines fully if that information would be helpful.
Yeah, Nicole, I think that would be helpful. And if there's any information behind those states, I think that's always helpful as well. And I have to recognize also, because there are differences, as we were learning today, between independent and umbrella agencies, et cetera. If you have any of that detail about the timing based off the entity of, or the composition or makeup of the board, I think that's helpful information as well. Rena, oh, sorry, Nicole, I saw are you going to comment further?
Oh, I was just going to say, to the extent that I can, provide that information, yes, I definitely will. I would say overall that with umbrella boards, specific legislation passed dealing with boards of nursing does end up taking longer under an umbrella function because there's a lot of shared functions and you kind of get in line for certain things, if you will. Whereas if your dedicated staff is only to the Board of Nursing and you have, your own licensing staff, your own disciplinary staff, et cetera, then, those boards may be quicker. But again, it's really going to depend. So I'll provide as much information as I can.
Thank you so much. And of course, public information only. Rena has her hand up, and then JC. And just before you make your comment, Rena, I just want to recognize that there's still a lot of discussion. So I think that there might be a need to continue the working group conversations. And I'd like to propose that as soon as the report is drafted, that we continue to meet to work through and make sure the report has that consensus. So I'll talk about that later, but just start thinking about that while Rena and JC ask their questions or make their comments. Rena?
Thank you, Laura. I'd like to thank everyone for the very robust discussion that's occurring here today and the specific scenarios that are being asked about and the information being shared. On behalf of RICO, I would like to respond to questions that a couple of the the speakers had regarding how will compact membership affect safety of nursing in Hawaii. Now, from RICO's point of view, because we were asked, right, how is the potential loss of revenue in terms of reduced licensing fees, Hawaii issuing single state licenses, going to affect RICO's enforcement ability? And because we are a self-funded department, any reduction in licensing fees, revenue based on that is going to affect RICO's operations. RICO is an enforcement agency, right? We have the responsibility for overseeing more than 50 professions and professional programs. So we have staff who interact with complainants at the intake stage. We have staff who do field investigations, and then we have our legal section, which includes attorneys and the legal secretaries. We have all these areas of responsibility. So it's one thing, to say that the NLC and the provisions of the compact do not hinder member states from pursuing enforcement activities. But the reality is that if RICO experiences a significant reduction in the revenue, I think we're going to see a corresponding effect in RICO's ability to timely and aggressively pursue the investigation and enforcement of any nursing complaints that should happen to come in that are related to multi-state licensed nurses.
Thank you, Rena. That's an important point. JC's hand, I don't see it anymore, but I thought JC, you had your hand up.
Laura, I just thanks so much, and thanks for all you're doing to bring all of this together. I agree with other speakers. This has been helpful to air some of the concerns and dissuade and kind of deal with some of these hypotheticals in a really efficient way. I was wondering if Nicole could talk a little bit about some of the funding mechanisms that could come to bear with the implementation and so forth. And if we don't have time, that's fine. I'm sure she'll share those at a later point, but I was just kind of curious if she could speak to those a little bit more, because that could be a great resource to the state of Hawaii and entering the compact if and when we go down that route.
So JC, are you talking about the implementation grants that I mentioned in the chat?
Yes.
Yeah, so NCSBN has provided funding to many boards to cover the costs of implementation of the NLC. And so the grants obviously have parameters, and I'm going to share that information with you all so that you have it. But a board would apply for a grant. They would list the activities that they wish for the grant funds to cover. That would include, any technology changes that are necessary. It has in the past included staff who were, there for setting up the processes and putting them into place for implementation of the NLC. There's been educational materials, the development of those materials and distribution of those materials to licensees, to facilities, employers, educators, etc. So states have used it in very creative ways. Most recently, Ohio had received a grant, and I can, again, share more information about the types of things that the grants cover. But I do know that they had a significant educational outreach program to make sure licensees understood what the NLC was, understood that they don't automatically have a multi-state license, that you have to apply for one, and they were able to utilize the monies in that way, which I think can be a great supplement. It's not funding investigations of multi-state licensees. It is strictly for the implementation process of the NLC.
Thanks, Nicole.
All right. We are about, Jen, sorry.
Sorry. I know.
I was looking at the time and I didn't see you.
It's okay. I was waiting for actually the right opportunity to bring this up. And I think Rena kind of sparked it for me, because honestly, I wasn't thinking about the revenue implications, so relative to enforcement. So that's really helpful to understand. Thank you. I had mentioned at a couple of meetings ago the concept of data and doing a survey, a professionally done survey in the community, so that I think it might answer some of the questions around that we're talking about, like what would inflow be versus outflow, which I think Senator talked about, right? To understand that a little bit better. And I know that there was a survey done but whether or not that survey was either statistically significant or how it was done or where, might raise questions. So I had sort of proposed in talking to OmniTrack about this, which is a local survey data firm, as well as the Hawaii Association of Health Plans, who I'm representing here, to see if they would be willing to fund that study. And there was interest in doing that. And so I talked to Leanne a little bit. We probably would need to sort of think about whether or not that's something that this committee would appreciate and support, and or if DCCA has the bandwidth to provide that data to OmniTrack, first they would have to work directly with them. But I was just waiting for the opportunity to bring this up. And if we have another meeting, we can talk about it then too. But sometimes it's helpful to have a little bit more and information to inform the conversation around what we think might happen by asking the people who are directly impacted. So that's sort of my tidbit for perhaps doing that. Thank you.
I would recommend that Carrie Oliveira, who did the first survey, but she is this Hawaii State Center for Nursing's PhD prepared big data scientist. So she is probably our foremost qualified person to inform the strategy on that, and has been doing the workforce research since 2016. But I think that's reasonable. I think if there's more questions about what nurses, we know that nurses have representation here through HGEA, through Hawaii ANA, through the many employers who are not working members, but then get funneled up through HAH. So we know that there's a lot of ways, as well as the Center for Nursing through our contacts, that individual nurses have kind of had opportunities, but it's a very large workforce. It's our 7th largest in the state generally, and the largest licensed workforce. So I think having more understanding doesn't hurt. I do question the timing though, if there, and we can talk about this further, but if we are to collect more data, it makes, you have time for fielding and then time for analysis. And my joke that to my staff is that November and December are fake months. So the amount of time we get before we have to submit the report, I have to submit the report by December 2nd in order to get it to the legislature in time. And so we are looking at 5 or 6 weeks of implementation. So it may be something that is outside of the working group because of the time frame. But then that doesn't mean that we can't informally continue to convene as entities who are interested in this information and the findings.
Yeah, agreed.
So I think practically and realistically, there's probably different ways to go about it. So I wanted to have that quick discussion. It does seem like there is some warmth to the idea, and I just want to recognize Tom in spurring this idea, that this idea came from him, but that there's probably opportunities for just the working group members to have an open dialogue without a scheduled agenda. Maybe we go through the report and say, what do we agree upon, what do we don't, and kind of classify it that way, or go through the individual items. I see thumbs up. So we have kind of working on that premise. We thought that it would be a welcomed idea. Amy's already set out the meeting, so we can have the meeting still every 2 weeks at the same time. If there is interest for the working group members to work in person, perhaps we could work with Tom, if we could work with Della Bilatti's office or Senator San Buenaventura to find a space at the Capitol so that we can all meet in person. That might be easier. And then we're going to try getting, I'm going to lock myself in an internet-free closet, and I'm going to try busting out the first draft of the report based off of all of the really wonderful minutes that Amy has compiled over the past several weeks. So I'll be working on getting that first draft, so then we can work through those, those agrees, disagrees, agree to see that there's many different positions on a certain item, that kind of thing. So thank you for your general welcoming of that. And if that is the case, we're at 12:03, so just keep your eyes out. We will plan to meet by Zoom in 2 weeks if we have not moved it into an in-person forum.
Thanks, Laura.
Thank Thank you, everyone. And
Thanks,
thanks,
Laura.
Nicole and Robert. I think you're still there. Thank you so much for being with us for the full duration of this meeting. And thanks to our DCCA team for all of the information you prepared. That was a very good presentation as well.
Thank you, everybody. Take
Thank you,
care.
everyone.
Thank you, everybody.